In 1973, the Supreme Court decided that in their case of Roe v. Wade, that under the right to privacy and due process constructed from a combination of the Fourth, Ninth, and 14th Amendment of the Constitution, a woman has the right to an abortion. The court stated that any future restrictions on this right could be justified only by compelling state interest and not constitute an undue burden on women seeking an abortion. This was a very vague way of saying that women could have abortions, but the state could set any restrictions if they felt necessary.
Flash forward to the year 1992 and the case of Planned Parenthood versus Casey. Prior to the case, according to Pennsylvania law, a wife must have obtained the consent of her husband to have an abortion. A minor must have gotten the consent of a parent, and a 24-hour waiting period had to be observed before an abortion. The court wanted to respect the individual states' want to protect unborn life, but they also wanted to give privacy to women and respect decisions made at home, in spousal relationships, and other family life situations. They tried to find some ground on which both state and individuals' rights were accounted for. On the grounds that some of the regulations set by the state created an undue burden for women looking to get an abortion, the court struck down the requirement of spousal notification. These are the specifics of the case, but in general, the Supreme Court reinforced and specified parts of the undue burden precedent set by Roe v. Wade by ruling that there could not be regulations set by states that merely presented an obstacle in the way of an abortion. The basis of this was found in the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This was done to respect the state's health regulations and women's rights through law.
In 2016, Texas passed, with the stated effect of ensuring safety for women obtaining abortions, a law that required abortion clinics to be regulated as ambulatory surgical centers and abortion providers to have admitting privileges at local hospitals. The law was called House Bill 2, or HB 2 for short, and though it was meant to protect women's health, this law had the de facto effect of closing all but 19 of over 41 abortion clinics in the state. The American College of Obstetricians and Gynecologists, in their amicus curiae brief, said, HB 2's ASC requirement and privileges requirement are contrary to accepted medical practice and are not based on scientific evidence. They fail to enhance the quality or safety of abortion-related medical care and, in fact, impede women's access to such care by imposing unjustified and medically unnecessary burdens on abortion providers. When people noticed that the clinics in Texas were closing and it was becoming harder for women to get an abortion, they began to question the true intent of the law and took action. The plaintiffs or petitioners in this case include Whole Women's Health, Austin Women's Health Center, Killeen Women's Health Center, Nova Health Systems doing business as Reproductive Services, Sherwood C. Lynn Jr., MD, Pamela J. Richer, D.O., and Wendell L. Davis, MD, on behalf of themselves and their patients, and they were suing John Hellerstedt, MD, Commissioner of the Texas Department of State Health Services, Mary Robinson, Executive Director of the Texas Medical Board, in their official capacities.
One complexity of the case was that the petitioners were physicians, not patients, and therefore had not actually received the damages from the law and were suing on the basis of somebody else's rights. In Justice Thomas's dissenting opinion, he said, "This suit is possibly only because the court has allowed abortion clinics and physicians to invoke a putative constitutional right that does not belong to them, a women's right to abortion."
This decision was widely considered the largest Supreme Court hearing on an abortion case since Planned Parenthood v. Casey, and as a result of its divisiveness, over 60 organizations, law experts, and politicians filed amicus curiae, or friend of the court briefs. The final verdict for the Whole Women's Health case v. Hellerstedt was 5-3 in favor of Whole Women's Health. Explaining that the precedents set by Planned Parenthood v. Casey allows the court to strike down this law, which based on unfounded health claims needlessly restricts abortion access and constitutes an undue burden for women seeking abortions, this means that future abortion restrictions will have to prove that they protect women's health. This is in addition to the traditional undue burden test and is a message that the court values the individual's rights over that of the state's interest to protect health.